if you would pay our client a third or a tenth or 100th of what you're about to pay your lawyers to defend this case, we would go away quietly. And that's not holding anybody hostage. I mean, our clients have rights. It's just the analysis. And that analysis does not fly. The federal government doesn't care. It doesn't cost the federal government any extra money.
Right.
But a private company who's hiring one of these huge law firms, it makes no financial sense, but that analysis never works.
Part-Time Hitter is brought to you by Friendly Forces, a 501c3 nonprofit committed to helping reserve component members seamlessly integrate their military service with rewarding civilian careers. We connect them with employers who value their unique skills and critical role in national security and advise organizations how to become more reservist-friendly. Check them out at www.friendlyforces.org. Friendly Forces is also brought to you by the Fratty Guard, a lifestyle brand for part-time hitters. Check them out at www.thefrattyguard.com and on Instagram at @thefrattyguard.
Okay, welcome to another episode of the Part-Time Hitter podcast. I'm your host, Eric Evans, and today I am joined by Brian Lawler of the Pilot Law Group. Brian is a 28-year Marine. He spent time on both active duty and a number of years with the Marine Corps Reserve, and now he is a practicing USERRA attorney, so an expert on all things USERRA. Brian, great to have you here. Thank you so much. So I would turn it over to you. I give you a very brief sort of background, but tell us a little more about your Marine Corps career and then how you wound up doing USERRA law.
Yeah, Eric, first of all, thanks a lot for having me. I appreciate the opportunity to be here. You're following. Hopefully this will be informative to all the folks you've got following you. You're right. I was commissioned into the Marine Corps in the active component and spent 11 years on active duty, flying F-18s. I did what was then called a forward air controller, a FAC tour, called JTACs now, with the battalion. Then I left active duty and then went into the reserve component a couple months later. And then once in the reserve component, still flew for a little while and then did all the various and sundry, staff officer gigs that the reserve officers tend to do.
All that fun
stuff.
Yeah,
11 years on active duty, 17 in the reserve component, activated, 7 or 8 times, I think, through my reserve career. So
wow.
As all your followers know, being a reservist or a guardsman or woman doesn't mean you're just doing 1 weekend a month and 2 weeks a year.
Yeah, I think you and I know that, but a lot of people who have never been Guard or Reserve, to include active duty, and certainly industry, certainly do not understand that, which is a large part of why this podcast exists and why my organization, Friendly Forces, exists. So, at what point did you A, become a lawyer, and then B, specialize in USERRA and this type of law?
Yeah, I appreciate that. It's so I went to law school. I was on active duty, actually. So my last 2 years on active duty, I was going to law school at night at the University of San Diego. I was an instructor at the F-18 training squadron at Miramar, and USD offered a night program, which was great because I could do both. It wasn't great because I was doing both, so I had to be out of the squadron usually by 4:30 in the afternoon to make evening classes, which meant I was there at 5:30 or 6 just about every day to fly. So flying all day, then going to school all night. It was a pretty interesting and sleepless 2 years, and then did my third year of law school while I was in the reserve component, and it was amazing how much extra time I had on my schedule when it wasn't full-time active duty. So found a job with a law firm. Originally, I started doing aviation law, which I still do some of, but the vast majority of my practice is USERRA. And when I joined my law firm, that was in late 2002, and in early 2003, everyone in the reserve and guard component got mobilized for OIF, me included. So I left my firm for several months and went back. Heard from a lot of folks while we were activated in 2003 about the way their civilian employers were treating the activation and warrants. So I started to get exposed to, I won't say smart on, but exposed to USERRA. And my first client, if you will, was a squadron mate of mine, and we were on a detachment down at Key West, Florida, and he just mentioned casually that his employer was making him take paid time off to do a 2-week annual training. And I said, well, I'm pretty sure that's not right. And so we called him that afternoon and his bank was credited. So from there, I said,
Wow.
there's probably more to this. Yeah, that was no kidding. That was kind of a fun story, but that's how it all started. The USERRA part, at least.
And so that was 2003, you said? 2003?
Yeah, I graduated law school in 02. Worked for a firm in LA for a couple years with that mobilization in the middle there. And then in 04, decided to hang my own shingle, started my practice. And then really 09 is when I just started to focus on USERRA. Our first USERRA case was a class action. So nothing like jumping into the deep end of the pool with a 10-pound brick, tried a class action right out of the gate.
Are there that many like USERRA specialists out there?
They're not. There are a handful of us. I mean, there are lots of attorneys who have done USERRA cases, and candidly, any employment lawyer could do a USERRA case because it's employment law. It is specialized, it's niche to the reserve and guard components. And I feel like having been in the reserve component for as long as I was, most of the lawyers that work with us are either former military or
Right.
a couple still serving actually in the one in the reserves and one in the guard. It's a natural fit, right? And what we've also found is from our client base, the fact that we've all served or are serving really resonates with them. Like, okay, you get it. If that makes sense.
Yeah. It's amazing after, post 9/11, we're still sort of at war. We still have people in Iraq and Syria. Still today, when you think companies would have sort of figured out by now, like what USERRA is and how to be compliant with it, how often people come to me with things their companies are doing that are clearly wrong, that I know are wrong, not as a USERRA expert or an attorney, but you mentioned the making your buddy take paid PTO for AT. Like somebody else just reached out to me and said the same thing.
Yeah, that's not okay.
Yeah, I said that that's they cannot do that. That's
right.
Clearly spelled out. So about every week, somebody comes to me and says, "Hey, my company did this or they did that. Is this allowed or what should I do?" So I'm curious, what are kind of the major trends or the major sort of repeating violations that you see in your practice as you are defending, service members around USERRA?
Yeah, it runs the gamut. I just want to address something you mentioned a moment ago. 9/11 is now 23 and a half years ago. I think at first, after 9/11 and a lot of flag waving, a lot of we support our troops. We thank you for your service to first responders as well. That's not a USERRA thing, but military and first responders, thank you. And now 23 and a half years later, it's the pendulum has swung to we're still dealing with this kind of thing. This as well as anybody. The reserve and guard components have been activated so much. I mean, op tempo, operational cycles. We could not have kept up the op tempo we've kept up for 23 and a half years without a robust reserve and guard service. Or component, excuse me. So at first it was everyone wanted to do the right thing. And those who didn't were, in my experience, generally ignorant of their requirements. And now I think it's become still like we're still dealing with this. So what we have seen more and more prevalently is failure to hire cases during the interview process or the application process. Someone divulges properly that he or she's going to be gone. They're in the reserves or in the guard, or they have a pending enlistment that's also covered by USERRA. Some people don't realize that. And the employer or potential employer would say, "Oh, well, that's not really going to work." Occasionally, they're fun enough to actually put that in an email saying, "Oh, hey, you're going to be gone so long, that's not going to work for us." Those are the easy cases. But what typically that would look like this: "Hey, we need you to work every Saturday a month." It's just kind of a normal work schedule, and the person says, "That's awesome. I can give you 3 Saturdays a month, and then I'll work Tuesday of the week I can't because that's I'll give you the time. I just can't do it on the Saturday." And they don't get hired. That exact fact pattern we've had within the last year. Failure to promote often happens, especially when someone, the egregious cases are failure to promote because you're in the reserves or guard, and it's never articulated as clearly as I'm about to say because my job would be much easier if it were.
Right.
But we don't want to promote this guy because he or she's in the guard of the reserves. what often happens is someone's gone for an extended period of time, and people do promote. Well, as you know, and hopefully your followers know, you're entitled to all the seniority-based benefits that would have accrued if you weren't on military service. So if that included a seniority-based pay raise or promotion, like step increases, we see that all the time in the federal government. Those are automatic. It's the discretionary ones that are a little tougher,
Right.
but we see those too, right? We see a lot of those where the higher ups, oh well, we don't have anything on which to base your performance over the last couple of years, so we can't really promote you. Well, that can't be used as a penalty against a service member.
Yeah. I was going to ask about this as well. I've dealt with that myself, where I've basically been told I wasn't going to get as large a bonus, or I wasn't going to be promoted because I was away for 5 months. Which, I think I mentioned, if you're going to do that, probably best not tell the service member
Right.
something like that directly. But when somebody sees this sort of thing, or has suspicions that they're in some way, maybe not deliberately, but being discriminated against, what is the correct course of action there? Because it's that balance between, well, I don't want to upset my employer, I don't want to bite the hand that feeds, but at the same time they're not being compliant with the law. So what do you suggest somebody does in that situation?
Yeah, that's touchy. I mean, when the employee is still employed, those are the touchy ones because, like you said, one, you don't want to bite the hand that feeds you. And we always tell our clients and prospective clients, hey, be the good employee, right? You want to be the good employee. Don't give them another reason to take some sort of adverse employment action. The wrongful termination cases they're usually like, the hell with those guys. I don't care. And, unleash the hounds. In the scenario you just presented, my advice is always at least start the conversation with your supervisor or HR, and don't go see lawyer on them, right? But at least say, hey, I'm not sure this is kosher, and what exactly is happening here, because what I think I'm entitled to is blah, blah, blah. Again, there's kind of a very fine line there. Again, you don't want necessarily the employee to say, hey, I know everything about USERRA, because they probably don't. And a little knowledge is a dangerous thing. So you don't really want to spin that tail too badly. But I would say the best course of action is to address it with your supervisor and HR. I think email is always the best. Make sure you save one to your personal stuff, kind of thing, just so you have that written documentation trail.
Assuming you start with your direct manager, supervisor, whoever, and that either that doesn't really go anywhere, do you eventually want to go to HR? Because the traditional wisdom is HR isn't there for you, they're there for the company, right? So do you want to at some point engage HR directly and either educate them or say, hey, you're non-compliant here?
Yeah, I mean, I think that is the answer. There's absolutely no requirement under USERRA to it's called exhaust administrative remedies. A lot of employment law cases, discrimination based on other statuses, you have to what's called exhaust an administrative remedy, like file a complaint with the EEOC or run a grievance process through your company if you are a member of a union and the collective bargaining agreement says this is the grievance process. USERRA says you don't have to do any of that. That's clear, with one slight exception. We'll talk about that in a second. You would be within your rights to go right out and hire private counsel. You could go to the Department of Labor, DOL vets, and initiate an investigation. If you are going to try to take care of it in-house, I think that's fine. You want to document that. And we see all the time after filing a lawsuit, one of the first things we get back from the lawyer that represents the other side is they never let anybody here know. Well, I think they probably did. You're saying they don't have any documentation of it, but that also doesn't mean that they can't just come find somebody like me and we review the case and say this is a viable lawsuit, so we file it.
What are your thoughts on USERRA as the way it's written? I've thought this myself, and I've heard plenty of other people say this, that USERRA as it's written seems somewhat weak because it seems like it's easy to get around if you understand what the law says on the employer side, as long as you don't make it obvious in any way that the military service was the reason you're getting rid of this person. You can just get rid of them. So my question is, what are your thoughts on that? And then B, since USERRA was written, has it been updated substantively in any way?
It's been amended quite a few times. In fact, most recently about 2 weeks ago. So let me take your first part of the question. First of all, I think it's a very robust statute. I actually think the enforcement in USERRA is great. It was just bolstered a couple of weeks ago. We'll talk about that specifically. But to your point about the enforcement, so let's use a wrongful termination case, because that's what we seem to be discussing. And employee A, service member, gets terminated, and he or she thinks it's based on their military service. Well, the company is never going to say that, right? Clearly, they're never going to say that. And they're going to say, well, they were terrible. And this is a fact pattern we have right now. Gentleman gets terminated. We file suit. They say he's always been terrible and he was terminated for performance reasons. Well, then you go to the client and you say, is this true? I don't think so. They never brought it up to me. And in this particular case, the other side produced a performance, improvement. It wasn't even a PIP. It was just basically some loosely worded, oh, this is what he did. He did this badly. Well, fun fact, that was created 2 months after they terminated him and 3 weeks after we filed the lawsuit.
Oh, wow.
So, yeah, I'm not saying anything further about that, but I wonder if a jury would believe that that was actually the reason, or it was after the fact. And so the legal term there is pretextual. So we say you fired this person because of his or her military service obligations or affiliation. And they say, no, they were always terrible. And we say, okay, well, let's see the documentation. And sometimes it's after the fact, or sometimes it's 5 or 6 little things that you would expect from a new employee, right? Oh, it's taking him or her longer to learn this thing or whatever. And so you terminated him. Well, in written discovery and in depositions, the first question we ask is, how many other people with documented performance like that did you terminate? And the answer is always 0. It's always 0. So, pretext is a fancy way of saying in our world, BS, for lack of a better term. Let's go to the enforcement for a moment and the amendments. So just a couple of weeks ago, it was the Elizabeth Dole Act, which just signed into law, I think on the 3rd, I could be wrong on the date, but just, a couple of weeks ago. And one of the things in terms of enforcement that the Elizabeth Dole Act provides is liquidated damages have been increased. So for your followers, what liquidated damages is an amount equal to your economic losses. So there's no pain and suffering in a USERRA case. There's no mental anguish. There's none of that. Every dollar that you could get is somehow connected to your lost income or lost retirement benefits or things of that nature. And liquidated damages would be an amount equal to that. So let's say, for instance, you were out $5,000 because you were terminated and you got hired again the next month, right? So you make $5,000 a month and you're out of work for a month. Your economic losses are capped at $5,000. Liquidated damages would be another $5,000. Well, in that case, and the new amendment, liquidateds are either $5,000 or $50,000, whichever is greater. So if you have a C-suite executive and their economic losses are huge, you could get the greater of the two numbers. But in the case we were just talking about, $5,000 for an entry-level blue-collar worker, $15 an hour, you could now get liquidated up to $50,000. So that's pretty good.
I mean, what if I'm a sort of a mid-career professional? I'm making $150,000 a year. I'm terminated, and I'm seeing people who have been out of work for a year, 18 months. So it's capped at 50,000, or
no? In that case, it would be the greater of. So let's using this hypothetical, you're out for a year and you made $150,000 a year, and we have an airtight case. And by the way, you only get liquidated damages if you can prove willful conduct on the part of the employer. Now, I've been doing almost exclusively USERRA for going on 16 years. We plead liquidated damages in every case, and I've never gotten them, at least not awarded by a jury or a judge. They're really hard to get, and I'm only aware of a couple published opinions in the whole country that awarded liquidated damages. So they're really, really hard to get, but they're there.
Why is that?
Proving the willfulness, right? So ignorance of the statute actually doesn't rise to the willful conduct. You'd have to show that the employer knew of its responsibilities and obligations under USERRA, and they still said, we don't care, and took the adverse employment action, let's say termination, anyway. And maybe it was the employee was smart enough to say, here are the exact provisions of the statute you're violating, and the employer takes that action anyway. That'd probably be a pretty good case.
So that sounds like a best practice then for anyone going through this, is to make sure you outline that during any sort of initial discussion with the employer, and then you can say, no, I told you what the applicable law was.
Yeah, and they're gonna. I mean, they'll have an excuse, and frankly, the standard, the burden of proof, the standard is pretty high anyway. So, yeah, it was nice to see, and I had some involvement in getting that actually written into the amendment, along with a couple of other provisions. It's nice that they did that, just because the small dollar cases, which we see so many of, for obviously, the pyramid of the military, so many, junior enlisted, they're not working C-suite jobs. Right. So their economic losses are, generally speaking, much lower. So that's just it's another way to hopefully make employers, abide by the law.
Do you think that would be, USERRA would be able to be amended to make ignorance of the law?
I don't think so. I think the willful standard is going to stick around. And I'm fine with it. It's a strong enough.
If I go and drive drunk and get a DUI, I can't say, I didn't know that was the law and not be held responsible. Like, I'm going to go to jail most likely. So
right, yeah, it's just tough to prove. They'll say that they being the employer would say, well, we're aware of the statute, we're aware of the law, we have the poster up in the break room, all that. We clearly didn't willfully disregard the statute. It's just your interpretation and ours are different. And again, I've never gotten them.
Okay. Well, I have a number of questions, some of which I was tempted to ask you during that discussion, but I'll wait till the end here. But I want to get to the Supreme Court case that you are currently leading about its differential pay for federal employees, correct?
That's right.
So tell us a little bit about that, what that case looks like, what you're fighting for, what the conflict is, and what we can expect from that.
So there's a federal statute that says federal civilian employees will accrue 15 days, 120 hours of paid military leave per year, period.
Actually, in the new NDAA, it's 20 days now. I just saw that.
Oh, did it change? Okay. Thank you for that correction. I was not aware of that. So X days, in this case, 20 days of paid military leave per year. And that's across the board. There's another statute that says if you are a federal service employee and you go on active duty during a war or national emergency as declared by the president, you get differential pay between your GS or federal civilian pay and your military pay. And that's what it reads. And then it says, as defined by, and it refers to another statute. Well, that statute's the definition of contingency operations. So what the federal government does is it takes the position that if you're on what they like to call voluntary orders, which we know are sometimes voluntold,
right,
and they're technically with the consent of the service member. So the orders provision that comes up most often is Title 10, Section 12301D. That happens to be the biggest pot of money that funds National Guard and Reserve activations. So it's the one that everybody gets. And the federal government, almost without exception, the agencies say, well, those are 12301D orders. That's voluntary. We're not providing differential pay. I have dozens of these cases. And our position is, well, the end of the statute, the differential pay statute, simply says any orders under a provision of law, which clearly Title 10, Section 12301D is, during a national emergency, and there are, I think, 42 or 43 of them right now. The one that we kind of focus on is the post 9/11 national emergency, which has been signed or renewed every September since 9/11. And the agencies just say, nope, that's not what that means. You have to be in a contingency operation. Well, that's not what the statute holds. So that was the argument at the Supreme Court just last month. In fact, not only was it our position was that you don't have to be involved in a contingency operation. That's not the definition. The federal government's position was, well, where it reads during a national emergency, means you have to be doing the national emergency. And our argument was, no, it's a temporal requirement. If the national emergency started on September 12th, 2001, and it's still going now, and you performed active duty during any period during that time, you're entitled to differential pay. I think that's the correct reading. That's how we argued it. That's how we briefed it. Ideally, what we asked, and in fact said to the Supreme Court, was best scenario is you simply wipe away the case that is before you, reverse it, and then hold all provisions of law, all periods of active duty qualify for differential pay. That would be the best case scenario.
Would people see retroactive back pay for if this was upheld from time?
Yeah. So if you let's just say you went on active duty and this has only been since 2008, by the way. So it's not like we're going back 50 years. You went on active duty in 2012 and you spent a year and you didn't even know about this. And now you hear about this case and you say, hey, wait a minute, you're still with the same agency. And by the way, you don't have to request it. They're just supposed to pay it to you. You go back now and say, yeah, hey, remember that time in whatever, 2012, 2018, where I went on orders for a year? I didn't get differential pay. I want it. Hopefully the ruling from the Supreme Court is broad enough to say that would work. Then you get into, well, that's a long time ago. There's got to be a statute of limitations. That's got to be foreclosed. There's no statute of limitations in USERRA since 2008. So you asked me about amendments earlier. USERRA was enacted in 1994. The 2008 amendment is the one that got rid of the statute of limitations.
Okay.
Yeah.
So, I mean, you haven't started actually arguing the case yet, right?
Oh, no, that case was argued on December 9th.
Oh, that was okay. I guess I don't really realize or understand how the Supreme Court works. So when can we expect what's the word? A decision?
An opinion.
Yeah.
Well, it will be before June, based on the timing, the typical timing. Probably March or April is what we're guessing. I mean, no one exactly knows, but I would think March or April we should see an opinion on that case. Like I said, we're hopeful that it's broad reaching, right? That it kind of wipes out this whole crazy argument that, if they're volunteer, they shouldn't get the differential pay. And what we unfortunately didn't argue, and I've been doing this in my brain now since the argument, the government stood up and said, well, we're okay with some of these, like the contingency stuff. Like if you're on 12301D orders and you're throwing grenades in Syria or dropping bombs or whatever, then that would count. But voluntary training shouldn't count. In my position, and you know this and your followers know this, we train exponentially more than we fight. And for things like the betterment of the service and professional development and promotion, if I can only speak to the Marine Corps side of the house, but you start corporal's course as an NCO, corporal's course, sergeant's course, the Staff Non-Commissioned Officers Academy, and then EWS, Command and Staff, and War College. You need to do PME to get promoted. Well, the only way you're getting orders to PME is on 12301D. And based on what the government just said in the Supreme Court last month, we just don't think that should count. That makes no sense to me.
So how do you feel, the Supreme Court's going to decide on this? Oh, sorry, I muted myself. Did you hear that?
I did. Yeah, I did hear that.
Yeah,
I've long ago stopped trying to guess what judges and juries do. I don't know. I know that we presented the case that we wanted to present. We presented it in the manner we wanted to present it. I know we got some very, what I would interpret as favorable questions from the bench. We got a couple that weren't so favorable. So kind of reading the tea leaves, it seems that we have some supporters and we might have some non-supporters. I only need 5. So hopefully at least 5 of them are on our side. So yeah, I wouldn't make that prediction. If I did, it would come out exactly backwards anyway. So,
right.
But I like the argument. I like the case. And I think we really tried to, keep it simple, stupid, right? KISS principle, and say during means during and all means all. And therefore, and since the words contingency operations are not in that statute, it should be anyone on orders during a national emergency should get differential pay.
Well, the implications are broad reaching. So I have kind of heard this come up on, the private sector side. I've seen companies say, well, the orders can't be voluntary, but they have no mechanism or no understanding to really enforce that, or I don't think they
Right.
really do. But if this decision says no, these do not count, then I imagine the private sector would kind of follow suit.
You would have to think so, yeah. And my understanding, my limited understanding, is that there is a statute that says if the private sector does something that's not allowed by the government, they could expose themselves to criminal penalties. But there's a certain, it's called mens rea. They actually have to know they're doing it and then do it on purpose, and that's probably never going to be the standard. But the trickle down effect, I just wanted to finish that thought for a minute. We were talking about schools and training. The trickle down effect is pretty obvious and simple. If I'm a federal service employee and I make $100,000 a year, and I'm a sergeant and I make $50,000 a year, and I have an opportunity to go to a school or some duty station, some activation for a year, but it's on 12301D, and that's going to cost my family $50,000, there's no chance I'm going to do that.
Right.
None. So it's going to disincentivize volunteer service for things that are both professionally developing for the service member and the strength and the operational capability of the service as a whole. I mean, you can see the trickle down, right? And if no one wants to go on these orders because they know they're not going to get differential pay, right now it's not that they're automatically excluded. I mean, the federal government does say 301D, the Office of Personnel Management, OPM, says 301D doesn't count. They say that unequivocally. Well, then you get into kind of a factual based analysis in each of the cases that I have. And by and large, in fact, with one notable exception, we've been successful in saying, look, this is what this person was doing, and this is why they should get the differential pay. But that shouldn't have to happen. The way the statute's written is you get it as a matter of right, as a matter of law,
Right.
and moving forward. So walking into those orders, I'm going to have my full paycheck for the next year. Not I've gone away for a year, I come back, and now I have to fight with the agency over do I or don't I rate that pay.
Well, and I think you and I touched on this when we first spoke, but I've heard this from so many people that the federal government is probably the single worst offender of USERRA out there, which is like sort of ironic. But yeah, the number of cases where reservists are fighting with their government employers is off the chart.
That's not anecdotal. That is an absolutely true statement. In my experience and in my practice, the federal government is the worst offender. And when you say it's ironic, that is absolutely true, because in the very first section of USERRA in 4301B, this is the quote: "It is the sense of Congress that the federal government should be a model employer in carrying out the provisions of this chapter." And I'm here to tell you that they are not only not a model employer, they're the worst.
Well, and that's why I don't want to spend too much more time on this because I have some other questions to ask you. But I always wonder. So I'm just some random employee. I submit my orders, my paperwork to my government HR person. Somebody in that chain, right, looked at that closely enough to say, oh, these are 501 3D orders. Those don't count, and made that decision to not do it. And I always wonder, like, usually these people aren't, especially it's a lower level person, like who is making these decisions and why, to the point that he gets, I assume, kicked up to the lawyers at the organization, then now at the Supreme Court.
Yeah, the lawyers don't get involved until I get involved, right? So it's always going to be HR. You just said something that's so important, and I think your followers need to know this. You said you're the good employee and you provided your orders before you went on active duty. And that's fine if you have them. And if you have them, I always suggest provide them. But guess what? No employer can demand orders prior to going on military leave. None. Not ever. Not for any length of time. And we see this so often. Like our policy, we get in this argument with companies all the time. Our policy says you have to provide orders before you go, or we're not, quote unquote, approving your military leave. Well, two fun facts there. One, they can't approve or disapprove your military leave. You're providing them notice and you're leaving. Two, they can't demand orders or any written documentation ever before you go. They can when you come back to show a few things like you weren't gone for more than 5 years, you served honorably.
Or I assume the rub is, no, you're going to provide us your orders if you want that differential pay, because we have to be able to calculate what that is.
The LES is, LES is, right. That I agree with. Although the statute doesn't say you have to, common sense says, well, how do they know what the difference in pay is? So yes, you're exactly right about that. But that's very limited to the differential pay scenario. But what we see in the federal government too, and all over the private sector is we're not approving your military leave. until you provide us orders. I have filed that lawsuit so many times, like, well, it's our policy. And here's the fun. When they argue that, the policy cannot supersede USERRA. Our policy says X. Well, your policy is against the law.
Yeah, a lot of these policies do say exactly that, although I have seen a trend where they are sort of caveating by say, or every effort should be made to supply the orders like before you go. But you're saying that you never have to do it at all.
Well, I'm saying the law doesn't require it. But what I'm also saying from a practitioner standpoint and to your followers to be good employees is, if you have them, why wouldn't you give them to them? And so when we get folks, so orders aren't always available, you know that. And what's interesting is we get this comment all the time about drill weekends. There's no such thing as drill weekend orders, right? You might get the annual letter from the command to the employers, and then you provide that in September and say, here's when I'm going to be gone for the rest of the year. Oh, by the way, there will be others, but here's at least what you know. That suffices. And that's always a good thing to give to your employer if you are, in a selective reserve or guard unit that does 2 weeks or 1 weekend a month and 2 weeks a year. But you get ADOS orders, or you have ADOS orders coming, or you think they might be, but you're kind of an alert unit, or you know how those situations work. Hey, we're going to go, and we'll figure out the admin later, but we're going to go. They can't keep you from going.
I could go down a whole rabbit hole with you about this, but just the fact that I've dealt with troubles getting differential pay per company policies because they need. I didn't have an LES or anything to show yet because the Army was so delayed in getting me that paperwork. So now I'm going without pay from both my civilian career and the Army for months at a time. I feel like I don't know, maybe there's a legal thing there where they shouldn't be allowed to do it that way. But
now that's what I'm saying. The LES is for the differential pay. That's kind of a carve out. That it makes sense, and you kind of have to provide the LESs if you want the differential pay. I mean, how else is accounting going to know what to pay you? I don't have a problem with that. That I don't have a problem with, because clearly you need to be able to calculate that number. What I do have a problem with, and we see quite often, is company X says, you're not going. We actually had someone get fired who said, well, I'm going on military leave. Well, we're not approving it. Well, you don't approve anything. I'm just telling you. And they first started coding them as PTO, and then when they exhausted, they're like, well, now you're out of time, and they terminated them. Wow. And well, you never gave us your orders. Like, well, they don't have to. That was a fun and rather quick case, because when we got involved, we kind of realized they had done something wrong. That happened.
All right. So we touched on this earlier on, and I wanted to ask this. So putting your Guard or Reserve service on a resume or mentioning it in interviews, yes or no?
I absolutely would. And I don't see why you wouldn't. I mean, one, a lot of these same companies, sometimes who are bad offenders, they love to wave the flag and say, we love our military, we hire a lot of veterans. Well, you and I both know, as well as your followers do, a veteran is different from an actively serving reserve or guard person. That said, I wouldn't withhold that. I don't know that there's anything unlawful about that, but I don't see any reason to withhold that, because we do see this occasionally, and we've seen it a couple times. Well, they didn't tell us they were in the reserves or guard. Well, do they have to? And you hire a young woman. Does she have to tell you she's going to get pregnant and how long she's going to be going? No, she absolutely does.
And that's my point. So why put it out there and allow them to discriminate against you when there's no legal obligation to do so?
Yeah, I mean, I get both sides of this argument, and I kind of come out on I would do it anyway, because first of all, again, going back to the majority of our client base and the majority of the military is junior enlisted. More likely than not, in that demographic, their military service and skill sets are going to be directly relevant to the job that they are applying for. Right. So why wouldn't you? I get it. And then there's the optics factor, which may or may not be lawful, but we've had a couple of really tough cases where something about service and notice. I mean, clearly they told their employer when they were going on leave, but the employer comes back, especially after we sue them, and says, well, we had no idea it was going to be this long. Well, that's not my problem. But we did have a case where someone did not divulge that he was in the guard, and until after he got hired, and then said, oh, by the way, next week. And it was like a week or two later. No kidding. He gets this new job. A week or two later, he's like, oh, yeah, I won't be here next weekend. Like, what are you talking about? Well, I have a drill weekend. Like, what's a drill weekend, and why are you going, kind of thing.
Right.
So that was tough. I mean, that's a total optics thing.
Yeah, and I would say generally, transparency is going to be the best path, but it can open you up to not get the job. So, like, I want to ask you this because this has been asked to me before in interviews, and I've said to the recruiter, "Are you allowed to ask me that?" But multiple times I've been asked
Yeah.
when I mention the Guard or Reserve. Oh, well, what does your time commitment look like? How long are you going to be gone? In the upcoming year. Um, are they allowed to ask that and
Yeah,
use that
yeah,
against?
that per se is not unlawful, and I know where you're going with this. So let me rewind my script for a moment. Based on the scenario we just discussed, I think the odds are so much longer against being discriminated against because you've revealed on your resume or in the interview process that you're in the reserves or guard than it is to be totally transparent. And something I said quite a while ago is we want our prospective clients and clients to be the good employee. We want to go into this smelling like a rose.
Right.
We did everything we're supposed to do. We provided all the notice. You had everything you needed. Is there going to be a failure to hire case because they said, oh, well, we don't want you because you're in the reserves and the guard? Fine, we'll deal with that and we'll take those cases, and we have. But to the extent you're going to go work for this company, I would suggest be as open and honest and transparent as possible. Put it on your resume. In the interview process, can they ask it? Yeah, there's nothing that says they can't ask that question. What they can't do is take some sort of adverse action against you, meaning not hire you because of that response.
Well, isn't that akin to asking a woman if she's going to get pregnant in the next year?
It is and it isn't. I mean, and let me just be clear: when there are these kind of close calls on reserve and guard status as a protected status, which it absolutely is. USERRA is an anti-discrimination statute. You are a protected class of persons. I will just tell you, my experience has been courts kind of give a little, but really, is it that big a deal? So from a practitioner's perspective, sometimes they look a little askew at, but why didn't you tell them? And that's, again, that's an optics thing. And remember, ultimately, if you were to take this case, move forward, and have to prove it in front of a jury, you got to tell between 6 and 12 people why you didn't tell them. And I don't think that resonates with the public.
Okay. Actually, some of these questions from the followers you've already touched on.
There's a good one. There's a good one in here. And your bullet is 3 years middle leave of absence. Employer offered you the same position, level, and pay as when you left. That's only legit if you would have had the same pay and position and whatnot over that 3-year period. More likely than not, you probably would have received a bump, whether it's based on your time in the company or the company increases its wages and salaries across the board because they did great that year. So if there is a benefit that you would be entitled to, that you would have been entitled to had you not left, you're going to get that. So it's called the escalator principle. So when you go out on military leave, you step off the escalator. And when you come back, you don't get back on the same step where you stepped off. You get back on wherever the escalator happens to be while you're gone. And if that includes promotions and pay raises that would have automatically happened while you were gone, then you're entitled to those. And that also includes retirement contributions.
But what if it's not, there wasn't a clear ladder of automatic promotions? It's like, well, you might have if you had been here, but we don't know. You might not have, and you were gone. So we're going to defer to not promoting you because you've been gone. Like, is that legal?
It is. Yeah, it is. And the test there is called reasonable certainty. Is it reasonably certain you would have gotten that promotion or that new job? And that's a fact-based inquiry. So that's tougher. Discretionary promotions and things like that, those are tougher. But we can do it, and we have done it. You look at the comparators. You work with 10 people, and you go away for 3 years, and 9 of the 10 have been promoted, and then they've hired 9 new people, and you're back with the 9 new people, and the 9 people you left have all been promoted. I would submit that 90% is reasonably certain you probably would have been promoted to.
Right. Do you tend to see, because I feel like that a lot of the people that reach out to me that have issues with their employers, it's always like a low level or mid level manager who's kind of giving them a tough time about, usually a lot of the time it's like shift type work, which like drills and stuff like that, tend to affect if you have a weekend shift or a night shift or whatever it may be. So, if you're a relatively kind of young, you're an E3 in the National Guard, and your manager at the warehouse is mad that you're missing shifts and now is not giving you new shifts or whatever it may be. Like, what is the course of action for that person? What do they do? I mean,
I'm glad you brought up shifts, because shifts, junior enlisted, probably the same kind of civilian job they work. This is great, and I think this is not as widely known as it should be, because we get this one all the time. So your shift, you do 12 hours, and your shift ends or would end at, I don't know, or let's say it starts or ends at, like midnight. You were midnight to midnight, and or whatever, 06 to midnight, something crazy on a Friday, and then you got to go to drill. Well, you got to drive 4 hours to drill, and that happens a lot. A lot of people drive a long way to drill. Do you have to work that shift? No, you don't. You don't have to work that Friday shift, because you're entitled to be fit and rested for your military duty. Okay, so now let's turn that around, and you finish drill at 1600 on Sunday, and you're supposed to start a midnight shift on Sunday night. Don't have to go to that one either, assuming you have to drive a little ways, right? So what USERRA provides is 8 hours of rest and reasonable transit time before you have to perform your next shift. So we see this a lot. We had a couple firefighters not that long ago who had 24-hour shifts, and they also can't make you go do part of a shift. Now, you could certainly volunteer to do part of a shift if the department says, sure, that's fine, but they can't make you do the whole thing. I mean, obviously, they can't make you do it where the two numbers would overlap, like when you finish your shift and when drill starts. Let's just say drill starts at 07 on a Saturday morning, like they often do. You don't have to work until midnight on Friday night, especially if you have to drive.
Well, the problem there is, let's say I provided my employer my drill schedule. They can say, okay, these days, got it, he'll be out. But now he's saying I can't work before because of drill. Right. And then it's like, they're going to say, well, that's not what this says. And I'm going to have to go, well, actually, if you look in the law, it's you can just see how quickly that's going to sort of deteriorate into probably a non-productive.
We do, and we see that a lot. And in fact, what often happens, and again, I would, back to my invitation to everyone to be the model employee, you want to let them know, hey, by the way, I have drill on Saturday and Sunday. That Friday shift, I'm not working because X, Y, and Z. It won't show up. HR would, like, say they have a calendar that everybody shares, and they say, oh, okay, well, Jones is out Saturday and Sunday. Well, he doesn't show up for his 8 o'clock or noon Friday call time because he's going to be done at midnight, and then he gets a no call, no show, right? That happened. We see that all the time. So probably best for shift workers like that to let their job know, yeah, by the way, drill is Saturday, Sunday. I'm not going to be at Friday's shift, and I'm not going to be at Monday's shift either, because it starts at 6 o'clock in the morning or whatever. It starts at midnight, whatever the number is. Does that make sense?
Yeah. So again, I mean, yeah, communication is key.
We get that all the time. And again, USERRA is a leave without pay statute for most of the time. So you're not expecting them to pay you for those missed shifts, but they also have to give you the time off to go to and come back from your drill site. I have plenty of friends that, as they start to get a little more senior, maybe they have command of a unit that's across the country and they've got to fly. They got to get there. They're gone all day Friday traveling to drill so that they can be the commander of whatever on Saturday and Sunday. And they're probably not flying back at midnight on Sunday night. Maybe they are. If they choose to fly back on Monday, Friday and Monday are protected, USERRA protected days. You're not actually performing military duty, but those 2 days are still protected.
Man, I wish I had known that.
Yeah, I get that from a lot of people. Yeah.
You're based in San Francisco, correct? Area?
San Diego.
Oh, San Diego. Maybe it was San Diego, but I think it was San Francisco. Enacted some kind of, city law that says, I think if you're a city of San Francisco employee or something, now you're entitled to like 3 months of pay differential. And that's one of the first sort of cases I've seen in the country where an area like decided on that.
Yeah, I've not read that. California provides 30 days of paid meal leave for municipal or state workers. So kind of similar to the federal statute on the 15, I guess now 20 days of paid meal leave. California is 30 if you're a municipal or state worker.
Okay. Well, we're coming up on an hour, so this has been a great discussion. I'm definitely going to have you back on from time to time because this will probably spur a bunch of new questions that people wish I'd asked that I didn't. But what are kind of your closing thoughts and advice to the community around USERRA and dealing with employers and all that good stuff?
Yeah, first of all, educate yourself. I mean, know what your rights are. Be the model employee. And even in the face of adversity, if things start to go a little sideways, we always invite our clients and prospective clients, ignore the noise, handle it as delicately and professionally and cordially as you can. If they're current clients of ours who are employed with the same employer we're suing, obviously we have remedies. We'll bring it up with the opposing counsel. But if you're not represented by counsel and you don't have a lawsuit yet or even a complaint, but you think things are not being done the way they should be, make the employer aware of it. First, make your supervisor aware of it. Get someone else looped in. However you have to do it, but understand your rights. The employees have rights, or the employers have rights as well. You can't just bail. Trust me, saw this case not long ago at all. The guy, no kidding, wrote his own orders on his home laptop. For periods, for drill weekends, that when the dust settled from the investigation, the staff sergeant who was the admin chief was like, that wasn't even a drill weekend. So that's probably not the right way to go about it.
Don't do that.
Yeah, don't do that. And that happened. That is one of my cases that happened. So don't do that. But if there is a question about the rights you're asserting and the employer's obligations, make them aware of them. Do it as politely and nicely as you can, but yet firmly. And if they just continue to say, no, that's not something you're entitled to, then, go find someone who can help. That's my best.
Quick question. Are there any firms on the other side of this that are known for defending these types of cases that you're constantly fighting against?
All the employment firms, the big employment firms, especially the bigger the defendant. I mean, we do it all the time. Fortune 500 companies, they are represented by the big axe wielding employment defense firms. We see the same ones fairly often. So, and the mom and pops are usually represented by a smaller firm because they don't have that much money. And by the way, just since we're on this topic very briefly, we see it from mom and pops and we see it from Fortune 500s and we certainly see it from the federal government. I will tell you that my vast experience has been mom and pops generally are ignorant. And once they get educated, even if it's because they had to defend a lawsuit, no one's out here to bankrupt mom and pop organizations that are, bootstrap. It's their family business. Like that's not it, but they do need to be educated and understand that they have obligations. And if their employees have military duties, they have to protect that. So those are generally just ignorance situations. The Fortune 5s and the federal government, they know exactly what they're supposed to do, and they just simply don't do it. They ignore it. They make up really fun stories after the fact, and then they hire those big axe wielding law firms. At least the Fortune 500 companies do, and make you work for it. And they don't play nice either, by the way, or fair.
Which is crazy to me because those lawyers are not cheap. So it's like, you know what? Why don't you just work with the employee instead of paying this law firm God knows how much time to fight this thing out?
If I could get paid my hourly rate for every conversation I've ever had with someone about if you would pay our client a third or a tenth or 100th of what you're about to pay your lawyers to defend this case, we would go away quietly. And that's not holding anybody hostage. I mean, our clients have rights. It's just the analysis, and that analysis does not fly. Certainly not the federal government doesn't care because they're staff attorneys that are the GSs as well. They don't care. It doesn't cost the federal government any extra money.
Right.
But a private company who's hiring one of these huge law firms, it makes no financial sense in my opinion or experience, but that analysis never works. They're like, we don't care. We would rather, and I've had a lawyer tell me, not one, I've had many lawyers tell me this. My client would rather spend 10x defending this case than pay your client $1. I'm like, oh, okay.
which is insane because they're supposed to be, shareholder value driven, have a fiduciary responsibility. And it's like, so yeah, I don't understand that either.
I never have, and I don't think I ever will.
So before we close out here, can anyone who's listening to this who is having issues, has exhausted what they think is in their ability to sort of deal with their employer, can they reach out to your firm?
Yeah, absolutely. You're welcome to put my contact information on the site. However, you're going to hang the podcast, you can put it all down at the bottom of it. Yeah, I'm happy to help. Our staff, like I said, all with one exception, two exceptions, excuse me, either are or were military and reserve and guard specifically. So we get it. We speak the language, and like I said at the very top, we find that our rapport with our clients, we're all brothers and sisters in arms. It really makes a lot of sense. So yeah, I'm happy to help, Eric. Any of your followers or listeners need, and even if it's just a question, just hey, I'm not sure this is kosher. Absolutely, reach out.
Absolutely. We'll get that information posted. And I'll just say, you and I kind of got connected through somebody and ended up speaking on the phone, like on a random Friday or something for about an hour. And I, we spoke and I said immediately, I like this guy. Like this guy gets it. So yeah, that's why I wanted to have you on the podcast. So we'll definitely get that information posted. And thank you so much for coming on, Brian. I definitely want to have you back, and we'll keep our eye on that Supreme Court case as well.
Absolutely. Eric, thank you so much for having me. Have a great weekend.
All right, you too. Audience, stay part-timing.